should be deciding which judges sit in the High Courts and Supreme Courts? Should it be the judiciary itself that takes the decision, or should the central government have a say? This is a debate that has been going on for some years now. But the fissures between the Supreme Court and the centre over this were laid bare in court today. Now, while hearing a case questioning why the appointment of 11 judges has been delayed by the centre, the top court observed, and I'm quoting here, that a person holding high position has made some unfortunate comments. It should not have happened. The comments being referred to seem to be the ones made by Union Law Minister Kiren Rijiju. He in fact spoke at the Time Summit last Friday, and when asked about the centre delaying judges' appointments, had this to say.
Mr. Rijiju, let me come back to this ratio, the lawyers and the judges. Now, lawyers, senior advocates, you mentioned ratio is smaller. But despite that, Mr. Rijiju, your government is sitting on the recommendations of the Collegium. I mean, you need to appoint judges fast. You're not doing it.
Collegium system is alien to the Indian Constitution. You tell me under which provision the Collegium system has been prescribed. But because the Supreme Court, in its own wisdom, through a court ruling or through a case judgment known as first judge's case, created a collegium. Now that collegium, whether the Supreme Court collegium or High Court collegiums, they recommend the name. And government has to do due diligence. Prior to 1991, all the judges are appointed by the government. What is the difference between consultation and concurrence? Is it same? What I'm saying is, as long as the collegium system is prevailing, I have to respect the system. But if you expect the government should merely sign the name to be appointed as a judge, just because it is recommended by the collegium, what is the role of government then? What does the word due diligence mean? Because the Supreme Court in its order itself has said that government has to do due diligence. So government is doing certain things which government is expected to do. So never say that government is sitting on the files. Then don't send the files to the government. You appoint yourself, you run the show then.
So what is this controversy all about? Simply put, it's about how judges to the High Court and Supreme Court get appointed. Judges in the lower court, that is all courts apart from High Court and Supreme Court, are appointed through the Judicial Services exam. But when it comes to High Courts and Supreme Courts, a collegium takes that decision. Now, what is a collegium? In the case of High Courts, the Chief Justice of that High Court, two senior-most judges form the collegium. In the case of the Supreme Court, it is the Chief Justice of India and four senior-most judges who form the collegium. Now, this group or collegium sends nominations of who should fill up vacancies in these courts, respectively, High Court and Supreme Court. The process is that this list is then sent to the central government, who can seek clarification if needed. They conduct background checks and then approve it. The approved list goes to the president, who finally makes the appointment. Now here's the catch. This government has been taking its time with approving the list of candidates for judges in Supreme Court and High Court. They say they're following due diligence. That's the process. The courts, on the other hand, see it as interference in the process. The top court today said, and I quote, "It appears the centre is unhappy its law NJAC could not pass the judicial test." Here it's important that I talk about the NJAC. That's the National Judicial Appointments Commission Act, which was brought in by the government in 2014, where the process of selecting judges to High Court and Supreme Court would change. The committee for selection would include the Chief Justice of India, two senior-most judges of the Supreme Court, the Law Minister, and one prominent person to be chosen by the President. This act was struck down by the Supreme Court in 2015. Since then, the top court has passed orders saying that if the entire collegium agrees on a name for the second time, the centre has to clear it within 4 weeks. However, there are some names of judges still not cleared even 1.5 years later. Now we need to put this in perspective because there is a debate on why judges should get to choose themselves. Why should the judiciary alone decide who sits on the bench of the Supreme Court and High Court? So of the total number of judges across courts, the fact is just 4% are chosen through this Collegium system. There are 24,631 sanctioned spots for judges in lower courts. All of these will be selected through an exam. In the High Court, the sanction strength is 1,108, and in the Supreme Court, it's 34. Hence, just a small percentage of all judges actually go through this process. But of course, the benches they preside over have, one could argue, more impact. So the question here is, why the open spat between Supreme Court and Sarkaar? I'm of course joined by an excellent panel today to speak on this. But first, I'm going across to Justice Deepak Gupta, former Supreme Court judge. Justice Gupta, thank you so much for speaking with us. Now, we know what has happened in court today. How do you see these increasing fissures between Supreme Court and government over the Collegium system?
I don't think it's some sort of a fissure, but the Supreme Court is actually saying what it should have sent and sent a message much earlier. I'm glad Justice Sanjay Kishan Kaul has taken up this issue. You see, what has been happening for quite some time now is that if the government does not like a name, it just doesn't say anything on it. It neither sends it back nor passes any comments on it and send it to the Collegium, but just sits on the file. Now, this has been happening many, many times, and I think, it affects the judiciary to a large extent. Not only the vacancies are not being filled up, but another important factor is that when the Collegium, both from the High Court and the Supreme Court, consider names for the High Courts or for the Supreme Court, they also look at the people in the level of seniority they will be appointing them. Who should be the senior most, who should be junior and all. Now, what has happened, even earlier it has happened, is that they pick a few names, say yes to them, and do not send the other names. So I think the Supreme Court was very, very justified in making the remarks which it made today.
You know, the Supreme Court has also responded to comments on the Collegium system from Law Minister Kiren Rijiju. He in fact spoke at the Times Now Summit. And apart from those comments, there seems to be a larger narrative that judges appoint whoever they want. Sometimes those decisions are partisan. Sometimes those from influential families get a chance. Does this narrative need to be responded to very clearly?
Yeah, it needs to be responded to very clearly. Let me tell you, Tamanna, that it's not as if judges alone appoint judges. They do. And this is judge-made law. But till the Supreme Court judgment is in place and till the judge's case, as we call it, holds the field, it will be judges who will be appointing judges in that sense. But it is not as if the government is not taken into consideration. When the Collegium of the High Court or the Supreme Court makes a recommendation, the inputs from the Law Ministry are considered. The inputs from the INB, the Intelligence Bureau, are considered. And then the names are sent. Sometimes the government may not agree with the name. If it does not, it will say, this is the reason why we don't agree to the name. And then they send the names back. Sometimes the Collegium, I know it as a fact, has agreed to the objection of the government and said, yes, we agree to this. This fact was not in our notice or whatever reason. And we are not reiterating the name. But sometimes they reiterate the name. Once the name is reiterated, then the government has no choice but to appoint. Having said that, to the second part of your question, is the Collegium system infallible? Definitely not. Does it need improvement? Yes, it does need improvement. And it needs more transparency. But I don't think we have a better system than the Collegium system. If we don't have, you see, finally, who will select? Who can assess the merit of lawyers better than judges? But yes, if there is some partisanship or, that has to be taken care of, and that can be only taken care of if there is more transparency while considering the names.
So there was a system which was proposed, the NJAC. It was struck down by the courts. And the top court referred to it today as well, saying that, is the government upset because NJAC did not pass judicial muster? Do you think there is merit in talking about a system like that where the government also has a say?
You see, what appears from what the law minister has been saying in the recent past, it seems the government is moving towards the line of passing another law like the NJC, maybe tweak it around a little bit. And let's not forget that the NJC was passed unanimously by Parliament. There were hardly any voices against the NJC. I am not totally against, personally, I am not totally against involving government official or government in the selection process. As I told you earlier, it is involved even now, but we could have a more open system where the views of the government are taken. I would be, in fact, happier if the discussions take across the table than behind the scenes. As long as the discussions with the government take place off the table, across the table, it would be much better. Having said that, I am clearly of the view that finally the primacy of the opinion should be that of the court and not of the government. It should be the court. The government should have no veto powers over what the court recommends. There can be discussions, and I'm quite sure that if 5-7 people sit together and look only at the interest of the judiciary, then there should be no problem in getting the names through. But if other interests are looked into, then there will always be problems, whatever system you have.
Let's cut to the chase, Justice Gupta. At the crux of it, is it about control over the judiciary? Because in our system, the courts can even hold the government of the day accountable. And that's the balance that's important to maintain.
See, in our system, there is the three wings of the government: the legislature, which is legislates, the executive, which sort of ensures that the law is followed, and the upholder of the constitution is the supreme, are the courts. Now, I am very chary and wary about a system where the government has primacy in appointing judges. They will pack them. It is regardless of the party in power. Whoever be in power, they'll pack them with people they want in the courts. You see, we always quote, do you think the American system is very good, where the president packs the Supreme Court with his or her nominees for the next 15 to 20 years? And you've seen in the result, Roe versus Wade, what is happening now in America. So I think the primacy should be of the court and the judges while making appointments. But I am not averse to having a representative of the government sitting across the table to discuss issues.
Thank you so much, Justice Gupta, for speaking with us so frankly on such an important issue. We're going to take forward this conversation. Tehseen Poonawala, political analyst, with us on the show. Rahul Mehra, a lawyer in the Supreme Court, joining us. Anurag Naidu, political analyst, and Karan Verma, author and political analyst, on the show with us. Welcome to all of you. Let me start with Rahul. Rahul, in your view, do you think that these are now fights that are out in the open? The Supreme Court has also spoken very, very strongly today. You're on mute, I think, sir. Mr. Mehra.
Yeah, can you hear me, please?
Now we can. Go ahead, please.
I'm so sorry. So this should have happened much earlier. I think the government of the day has been sitting over recommendations made by the Collegium for way too long. At the core of the issue is the independence of judiciary. Obviously, I think I completely agree with Justice Gupta, who was there on a show earlier, when we say that obviously the collegium system is not a perfect system. It needs improvement, it needs some tweaking, but the solution doesn't lie in handing over the control to the government of the day. Make no mistake about it, all political parties cutting across party lines would like a committed judiciary. Would like judges to toe their political lines or their agenda or their policies or whatever it is called. But at the end of the day, there are checks and balances in our system. And judiciary is the only institution which protects the Constitution the way it does.
Right.
So the final check and balance is in the hands of the judiciary. Now, look at how the transfer of judges happen in our country, which is so demoralizing. If you give a judgment which is not liked by the powers that be, sometimes we see that, and there have been cases which have been reported in the past where overnight judges are transferred. Then there is the issue of the MOP, which is lying with the government for way too long now. That has not been finalized. It was sent back by the court to the government, and the government has not really taken a decision on it. I would say that, at the end of the day, we want transparency, we want accountability, and we want objectivity.
So long story short, Rahul Mehra, you think the collegium system is fine as is? This is what we should continue with.
I don't think it's a perfect system, but it's a much better system. Unless we can find a better system than the collegium system must continue. Definitely there should be absolutely arm's length distance from the government of the day in deciding who the judge should be, because otherwise I think justice and in a democracy where the rule of law which prevails would be a thing of the past. And we are a vibrant democracy, the largest democracy, and we must protect the fundamental and the core of Indian judiciary, which is its independence.
We have to understand over here that we're talking about this in context of a basic tenet of our democracy and not about one party or the other party. There happens to be a BJP government today, but these rules are crucial for how our democracy functions. In that context, Karan Verma, why do you think these inordinate delays in approving lists given by the Collegium? Up to 1.5 years as per the judges.
Tamanna, I was there when Mr. Kiren Rijiju made the statement at the summit, and I congratulated him because he actually addressed the elephant in the room. The collegium system is opaque, which needs transparency. It's not me saying that, it's Justice Chelameshwar who said this. The primacy of the judiciary in appointment of judges is a basic feature of Constitution, is basically flawed proposition. I'm again quoting Justice Chelameshwar. The fact of the matter is that when we trace back our roots, Article 124 and Article 217 of the Constitution, it was the president who was supposed to do the appointment, and the Chief Justice was always the consultee. How over a period of time, over the first judge's case, the second judge's case, it slowly morphed into the CGI doing the appointment and the government not even, the president not even being reduced to a consultee, just being someone who has to obey what has happened with the CGI. How we've come this far is something that dazzles me as someone who does research on public policy. How the government is ostracized, someone who represents the will of the people and they are accountable to the people and they go back to the people after every 5 years, they are ostracized as if, their shadow should not be cast.
Who is ostracizing?
I agree.
1 minute. Who is ostracizing Karan Verma? That's a big allegation. Who is doing the ostracizing?
Throughout the NJAC debate, everyone from the legal fraternity, they maintained that the independence...
debate is Sarkaar 2015.
Yes,
it's been thrown out by the courts.
It has been thrown out by the court, but the issue hasn't died down, has it? I mean, the fact that today we have these inordinate delays, the fact that we still don't have a transparent system in place as far as appointments is concerned. And who decides the independence of the judiciary? Is the judiciary going to decide whether they are independent or not? With
Is it going to be the
71,000
government? Was
cases.
the question. Tehseen, your response to the points that Karan Verma is making, that this is an opaque statement. The minister at the summit said it is alien to our constitution.
First, one unsolicited advice, because, Rahul Mehra will tell you lawyers never give unsolicited advice. The most honorable Law Minister of India should speak a little less and should work a little bit more and stop rubbing the judiciary the wrong way. There are 2 or 3 questions that come into being here. How does the judiciary appoint its own judges? That's the narrative that is spread. That's incorrect. First, the judiciary gets its authority from the basic structure of the Constitution. Basic structure of the Constitution mandates that the judiciary maintains an arm's distance from the government. Now, number 2, why should the government appoint judges? Because in 46% of the cases, this is the Law Ministry's record, the government itself is a litigant. How nice, na Tamanna? I am a litigant and I will appoint a judge. मेरा कातिल ही मेरा मुंसिफ है, क्या मेरे हक में फैसला देगा? Where will ordinary citizens like you and I get justice? The judges, if the litigant is going to appoint a judge themselves, that is the government of India. So please, the government needs to be out of these cases. Now, point number 3. Karan very rightly alluded to Article 124, the most honorable President of India, His Excellency the President of India or Her Excellency appointing the judges. Yes, that is true, but the President does not appoint judges on their own whims and fancies. It happens on the aid and advice of the Government of India. And the Government of India cannot reject the aid and advice of the Collegium system. And that's what maintains distance. Now, let's just go back to one of the most mature democracies. Let's look at United States of America. Let's look at what's happening there. You have either a conservative judge, you have either a liberal judge. You have judges lobbying with lawmakers. You have either the Democrats or the Republicans trying to pack Supreme Court with nominees of their choice. Do you want that in India? You already have a problem in India where certain judges, upon retirement, get post-retirement judge benefits. I'm in agreement with Karan to an extent. Yes, the Collegium system needs to be more transparent. It started moving in that direction. As one of an activist, legal activist, we've now got the RTI moving for the Supreme Court. The Chief Justice announced it. We fought for that. Yes, it should be more transparent. Yes, there should be live streaming of the Collegium meetings. Yes, there should be minutes maintained. Yes, those records should be maintained. But the government is not at liberty to reject an opinion of the judges. And it's only 4 to 5%.
No, so what is happening now, once we are in a strange situation. What is happening now is that there are no outright rejections. It's just no movement, no decision.
So
that question was asked. That question was asked to Mr. Rijiju, saying, "Don't say we are sitting on files, otherwise don't send us the files."
But they are duty bound to do it in 4 weeks. They cannot hold it longer than that. So the court should step in further. If within 4 weeks the government does not give a no, or does not reply back to the file that the court has sent back or the honorable judges have sent back, appoint the person. Let's see what the government does.
So the court today actually said, don't force us to move in a judicial manner. Anurag Naidu, I want to hear your views on this. I want to hear your views on this, because it seems today from the observations, and of course we'll have to wait to see what happens in this case, what is in the judgment, etc. Prima facie, it seems patience is wearing thin in the judiciary on these delayed appointments. Yes, Anurag Naidu, that question's for you, if you can hear me.
Hello, is that to me, Tamanna?
Yes, it is, Mr. Naidu.
Yeah. No, I mean, look, I would like to say a lot of answers lies in what my dear friend Tehseen Poonawalla has said. There are 2 things. The sentiment around Supreme Court in general, and I'm speaking in the capacity of being an activist and a political analyst. What I can tell you is, the Honorable Law Minister should stop rubbing the Supreme Court in a wrong way. And I mean, why do we have this feeling that Supreme Court is sacrosanct? With all due respect, nothing in India, when a democratic country, should be treated as sacrosanct. And when we are saying a lot of time, government is a litigant, there are chances, there have been cases where the judges also have been litigants. So who decides what's right and what's wrong? The whole prima facie argument is, and everyone, both sides, even the government, Mr. Rijiju has been very bold enough in admitting that yes, the system should improve, the system should upgrade for good. And on the other side, a lot of Supreme Court former judges who have been on panel on several media channels have agreed that yes, there should be some kind of involvement from the government, but not an outright taking control through NJAC or any other way. It should be a hybrid system. Now, what government is also saying is absolutely right. If you want to just send this file and give a deadline, boss, you need to give me back in 4 weeks, then why are you even sending? I mean, if that's how you want to direct. So I think that there is merit on both sides.
Explain to me, Mr. Naidu, 4 weeks is not enough to do due diligence, background check, security check for the government and then say, okay, I have a problem. And that with the 4 weeks deadline is if the government has first come back and said question mark on these names, if the entire collegium unanimously goes back and says, yes, we want these names, then they have another 4 weeks. It seems reasonable. What do you need 1.5 years for?
There are
my
two sides.
point is, if you don't want to do it, why are you using the stalling mechanism? If that's the case.
Because Tamanna, clearly the second time when you refer back, right, and when you get the same names again to review, there is hardly any chance left with the government to accept or reject. So in that case, government is in kind of a fix, and of course, I mean, if they're not happy with the current system and if they don't see things changing, I think, of course, I don't agree with the fact that, there can be an unlimited, stay or unlimited kind of not being able to decide. And I think if things need to change, we need to speed it up, fasten up, and things need to change. So I think
how will it change? It went to court. Rahul Mehra is coming in. There is the thing is, we have to make it clear to our viewers, even when we're discussing the collegium system, this is not a if or situation. There is no ambiguity. As per the courts, as per the constitution, this is the system that exists. The only question is whether it's being followed or not. Yes, Mr. Mehra, your response.
So there are two things. Does the government of the day believe that the judgments which are passed by the apex court, the highest court of the land, are to be followed or not? First of all, they need to decide that, because right now what is happening is, you are sitting over the files. You've made a complete mockery of the entire system. The judges' cases, whatever has been held out there, you are actually throwing that to the wind. And you are assuming that the Honorable Supreme Court will actually sit quiet and not take you head on. Obviously, these are very sensitive issues. And there is a huge amount of restraint which is applied, and rightly so, by the judiciary. But, you can't really test the patience of the judges. And this is exactly what is happening right now. When I say mockery of the system, look at this. 10 names which are recommended by the Collegium, 7 approved, 3 put in the back burner. They are not decided for a year and a half. Then when the reminder goes to the government, then the government objects to it. In some cases, hasn't even objected to it and still sits quiet. In some cases, objects to it. The Supreme Court then, Collegium, reiterates the position. And after the reiteration, it is binding and mandatory for those names to go through. And the government of the day, again, sits on them, doesn't even respond. How do you expect the judiciary to respond to this kind of muscle flexing by the government of the day?
That's the problem, Karan Verma, muscle flexing.
The judiciary has been very kind to the government. And you have rightly said, this is not about this government. This is like laying down the principles, the ethos, the basic structure of our constitution, independence of judiciary.
So Karan Verma, if you heard Justice Gupta, who I was speaking to earlier on the show, and he talked about the fears that a government, and again any government, will just staff the judiciary or the top ranks with people of their choice. We have the American example.
Yeah,
we have the American example before,
which is a
before
disaster.
us. So we don't want that, right? So you agree you don't want that?
Of course we don't want that, Tamanna, but we want a far more sophisticated system where, yes, the will of the people, which is expressed in the government, they should have some say. I'm not saying it should be an exclusive club of any organ, whether it's the judiciary or the executive, but there should be adequate representation from all organs. You can't just have a Gymkhana club where the judicial members elect further members and they decide, and merit takes a backseat. What works is proximity and contact. We can't be sitting on that. And if anyone's patience is being tested, Mr. Rahul Mehra said the patience of the judiciary is being tested, the patience of the people of this country has been tested. Where you have 47 million cases pending and 71,000 cases pending.
But Karan, that's because there are no judges. Because
Let me
there are no
complete.
judges. Because the vacancies are not being filled by the government.
Well, this is a poor alibi. Fine. You
How
can't.
is it a poor alibi? Logically,
It is a poor
logically.
alibi. Look,
Logically, no. Just hear me out, Karan. Hear me out. Just hear me out for a second, and then you continue. I'm saying you have linked this whole situation to patience of the people of this country are being tested. I just want to test that theory and that argument because, you know, it is a sore point. The long time and the years it takes for anything to be solved. Now, where do most people go with their cases? Let's start with that. And I want to just pull up that graphic because we did a little bit of research on this. Most people in this country go with their cases to lower judiciary. Not everyone goes to the High Court and the Supreme Court. You have to cross several thresholds before you get to High Court and Supreme Court. Most people cannot afford lawyers in High Court and Supreme Court.
In fact, access to
Correct?
justice. In fact, access to justice is a big
How
issue.
how are judges in the lower judiciary? How do they get to that position? They sit for an exam.
They sit for
It
an
is
exam,
only
right.
4%. It is only 4% of all sanctioned judges that get through by the Collegium system. Let's bust some myths here and just put those facts into perspective, Karan Verma. When you are evoking the tariq pe tariq pain of the Indian citizen, you're not actually putting it into perspective.
I am. You're not allowing me to. I am saying that
Please go ahead.
even if we talk about just the Supreme Court, there are 71,000 cases pending right now. Now, this is something as a citizen I am appalled with. And where do I go? If the Supreme Court is supreme and they sit in judgment of their accountability and transparency, I will quote Chief Justice N.V. Raman. He said pendency of cases is not a useful indicator of how well a system is doing. Now, if you don't think pendency of cases is an indicator, what have we made the judiciary? Is it at a pedestal where we can't even scrutinize, where we can't even think of reforms within it? They preach sermons to the Election Commission of how appointments can be fair, and here we have a Gymkhana Club system where members appoint members.
Okay, Tehseen, your response to this Gymkhana Club system. You know, Karan is actually echoing a lot of stuff you hear and see on social media. It is a stream of thought saying, what is this Gymkhana system? Maybe people who want to be part of that Gymkhana system are saying, why shouldn't we have a say? Your response, Tehseen?
No, the government of India has a say. The government has a say in the appointment of judges, any judges, including in the collegium system. If, for example, hypothetically, the Supreme Court sends some names, let's say they send Rahul's name tomorrow to become a judge, the government of India will look at it, the IB will look at it, and they have a right to reject it with valid reasons. And there have been various judges who've been rejected for various reasons, and the court has agreed to it. There have been various reasons in the collegium system where a judge who's been appointed as a Chief Justice of one High Court, the government has said no, so he's gone to a smaller court in that extent. Where we know about that. So there have been government intervention, but can the government, which is a litigant in 46% of the cases, decide solely who the judges will be? Then why should it be only judges? Government. Why not even leader of the opposition? So
yes,
the system
yes, it should be.
Let me make one more point. This idea that there are so many cases, for example, like Karan said, pending in the Supreme Court. Today we know, and I was with you, Tamanna, in the Morbi case, for example, in the High Court, the government bureaucrats don't turn up despite the High Court summoning them. What will happen? The cases will keep pending. The SG doesn't turn up. So many cases, the ASG doesn't turn up. The cases will be pending. Your lower courts are not giving bail. So ultimately, yes, you need judicial reforms, but does that mean the government becomes the arbitrator of those of the judges? I am sorry. I will be comfortable, and most people, with an independent judiciary. If the government today is going to interfere in the judiciary, tomorrow the government will interfere in media and say, why is XYZ the editor? Government should have a say. Why is ABC the editor? Government should have a say. Where does this end? The government has no right by the Constitution of India to intervene in the justice system. It's a separate wing of governance.
So you know what? Now let's come back to what the issue today is and what this fissures, as I call it, is all about. What Tehseen is saying, what the Supreme Court is saying, what Rahul Mehra is saying is the law of the land. Karan, you'll have to agree. The collegium system is the law of the land.
It is the law
it's ratified. We can keep debating to kingdom come, but it is the law of the land. There's no doubt about it. The question today is that by quote unquote sitting on files or taking inordinately long amount of time to clear these names and following the process, in a sense maybe putting a spanner in the works, is that law being subverted? Because the government is not liking these choices of judges, you just sit on it because they're part of the process. That's the question, that's the allegation, and that's the PIL in court right now.
Tamanna, Mr. Arun Jaitley, late Arun Jaitley, rightly addressed this matter. And he said that unfortunately, Tehseen keeps saying that, they have a say. The executive has a say, the law minister has a say. As far as the IB background check and other things are concerned, it is largely a clerical role. That is what it is reduced to. All they can do is flag a concern or two. And in the end, if the Collegium doubles down on their choice, they have no option but to agree it. So it is barely a consultative process. It is a concurrence, process of concurrence. That is what it is reduced to.
Okay, but if they don't...
Just 10 seconds. Just 10 seconds.
Yes,
Karan, where are they? But Karan, where are they agreeing to it? Let's say the name is recent. They're sitting on the files forever. The law of the land is within 4 weeks. They have to send a name, agree. They don't. They sit on that file forever for over a year and a half.
That is where I agree with Tehseen. That is where I agree with Tehseen that they should not sit over the files. They should at least give their objections, whatever that may be. But this has to change. There has to be consultation. You can't just have a one-way traffic where you want the executive to just concur with whatever choices the Collegium has. That sounds like a bully to me.
Rahul Mehra. Yes.
So there clearly there is a consultation. When you send the file from the Collegium of a particular judge, name being there, the government of the day, through its agencies or otherwise, can object, and those objections have to be in writing. What else is consultation? Obviously, you have a right to say that Mr. So-and-so or Miss So-and-so, we don't agree with those names. But you have to give reasons for it. And then if the reasons are valid enough, the Collegium obviously sees, validity and validates it and then doesn't reiterate. But if the reason seems to be stemming out of some political objective, obviously the Collegium will then reiterate in order to save and protect the name of that person whom they have initially recommended as well. It is the bounden duty of the Collegium, because the person whose name is there, he or she can't defend themselves. It is the Collegium who has reposed the faith in that particular lawyer to become a judge subsequently. It is their bounden duty to ensure that the fair name is not sullied because of some extraneous reasons. And at the end of the day, one thing we must be clear about, judges sit for a particular reason. They have to impart justice. And when they take oath, they have to say, they have to believe in what they say, and they have to act on it. That I shall impart justice without fear or favor, without ill will or affection. If there is fear because there is something happening, of the government, if there is favor because, there is somebody's, like you're saying, there's a cozy club of sorts. Obviously we are not saying the Collegium system is a perfect system, but is the remedy going to be getting government into it and government control over it? Obviously not. This remedy is unacceptable. You want to open it up. You want to have transparent system, the opaqueness to go, accountability factors to be there, resolutions when they are passed to be shared and on the website. I'm all for it. Obviously there are cases where undeserving people have been brought into the system. But no system is a perfect system. We all know we are not living in utopia. Every system will have its flaws. The point is you have to take the good with the bad, but it has to be
Are we going to see
90-10, or is it going to be
all right.
a 60-40?
So everyone agrees that if there is an issue, if there is a problem, if there's an ongoing debate, you have to find another solution. You can't sit on the decision. You can't sit on the decision. I think everyone agrees on that, and that's an important...
But that is exactly what the mockery of the system is. The government of the day sits on it for not weeks, but months, but years. There are cases...
Mr. Naidu, quick response.
Name has been reiterated.
Yes.
The government doesn't believe in a certain way of living, and therefore, because of their own myopic view of a living of a citizen, they have.
We are assuming that because there's nothing been said either way. We're assuming that nothing's been said either way. Yes, Mr. Naidu.
Yeah, I mean, just a quick response. I mean, nobody's saying that, we have questions on the integrity of the judges. They carry high level of integrity. And I've always said they've been always benevolent and they stood up for the rights of the common people against the governments. And that's the most fantastic part about the judiciary. Nobody is questioning that. But the point is, if there can be an improved system, why are we targeting government which is led by a political party and trying to politicize the situation? If you don't like the government,
no one trusts any government of any political party to leave the judiciary alone. 1 minute. Mr. Naidu, very clearly I've said in the beginning of this conversation, it's not about a political party. No one trusts any politician. No one trusts any politician.
I'm saying, why don't
Which party protested the NJAC in court? 1 minute. In 2014, 1 minute. Mr. Naidu, 1 minute. Which political party stood up and protested the NJAC when it was passed in Parliament? Nobody. Everyone was okay with it.
Tamanna, why
no one wants to give up the chance of potentially controlling judges. You think any political party will want to give up the chance of potentially controlling judges?
Why do you
make
the political class such a big monster?
Oh, come on, Karan. Come on.
Are.
I know you're a political analyst, but you have to analyze the politicians, not be one of them. All right, we'll take a very short break. It's unlikely we're going to solve this very huge issue of the Indian judiciary in this evening. But I want to thank everyone for joining us on that debate. We're taking a